In our webinar. I wanted to go over a few little housekeeping details before we get rolling. I also have Brandon Peters with me, and he and I are both going to have an opportunity in just a few minutes to introduce ourselves. But first, let me cover a little computer aspects for each of you. You are muted, so we are not able to hear you, but obviously you can hear us. We also have on your screen a chat feature. And if you want to minimize that chat feature, all you have to do is press the little orange button associated with it, and it will minimize it. On the other hand, if you want to send us a couple of chat messages during the webinar, feel free to do that. Speaking for myself, I'm probably not going to try to run the program and do the presentation and review the chat messages, but we welcome the chat messages, and we will have an opportunity to address them either this afternoon after the webinar, or we'll get back with you at some point by email. So I just wanted to mention that from a housekeeping standpoint. Another thing we're going to do today that's a little different than what we've done in the past is there's a way through GoToWebinar, which is what this software is, that we can actually conduct an online poll. And so we've created a couple questions that we're going to cover at the very end of the webinar. And we're going to actually poll, and hopefully we'll be in a position from a technical standpoint to let you know the outcome of the poll before we actually terminate the webinar. So that's something we're trying today for the very first time. And before I actually turn it over to the introductions, I want to thank our co-sponsor, the University of Florida Levin College of Law Institute for Dispute Resolution. We co-sponsor all of our webinars with them, and we really appreciate their support. Well, my name is Michelle Jernigan, and I am a full-time mediator with Upchurch, Watson, White, and Max. And hold on a second, I'm trying to, there we go. And I want to take just a minute and to introduce myself, and then I'm going to give Brandon the same opportunity. I've been an attorney since 1982 in Florida, and I became a Florida Supreme Court Certified Mediator in 1988, certified in Circuit Civil, Appellate, and Family Cases, also Federal Court Certified. And then in the 90s, I decided to become, to take my certification as an arbitrator. And then I joined our firm in 1992, Upchurch, Watson, White, and Max, and I've been a shareholder with the firm for a number of years. Here at Upchurch, Watson, White, and Max, UWWM for short, we are full-time professional neutrals, and we offer services in mediation, arbitration, special master work, and mediated case management. So that's enough of an introduction for me, and now I'll give Brandon the opportunity to introduce himself.
Thank you, Michelle. Good afternoon. My name is Brandon Peters, and I am one of the newer full-time professional neutrals at this firm. I have been a professional neutral for 3 years, but I joined Upchurch, Watson, White, and Max in August of last year. I, like Michelle, am a federal court mediator. I'm also a certified circuit civil mediator, appellate mediator, and family mediator. In addition, I'm an arbitrator qualified under the rules of the Florida Supreme Court, and I am a FINRA arbitrator. That's the Financial Industry Regulatory Authority that mediates securities industries disputes, anything from disputes such as you shouldn't have put my 91-year-old grandmother into risky put options, to broker-dealer disputes with their own employees that can include a whole range of issues such as unemployment severance, Title VII issues, and really the sky's the limit with the FINRA cases. I mediate for the American Arbitration Association, and sort of go where needed. with that, that's enough about me, other than I'll say before I became a full-time professional neutral in 2012, I did have a civil trial practice in Florida and in Arizona for 23 years.
Thanks, Brandon. And we at the firm are really pleased to have Brandon with us, and thank you for mentioning that it's qualified arbitrator. I know I stumbled over that a little bit. Yeah, as opposed to certified, it's qualified arbitrator. Well, so now we're on to our topic. And before I get started, I want to say that Brandon and I were just sitting around having coffee one day, and we were talking about the host of issues that can arise when you hire a mediator who's also still practicing law. And so out of those discussions grew this presentation, and we hope that, so here's the bottom line. We believe that there are some advantages to hiring full-time professional neutrals, and that is part of, that's not solely what we're going to cover in this presentation, but that's part of what we intend to share with you this afternoon in our webinar. Now, one of the things that always comes up when we have a phone call coming into the office to set a mediation, the question is always raised, Kathy, Rose, has the mediator that you were suggesting we use, has that person had experience mediating this particular type of case? Now, what we label this is subject matter expertise. And you can see there from the illustration that there's probably some different perspectives, whether you're the lawyer in the case or the mediator in the case, or whether you're a plaintiff or a defendant in the case. You have a different perspective as to whether that mediator really does need to have what we call subject matter expertise. Now, I'll tell you that most lawyers want their mediators to have some experience in the subject matter in which they're going to mediate. But having said that, I will tell you that the mediators believe if you offer up the right tools to us and give us the right information, we really believe we can fix anything. We believe as mediators that we can mediate any kind of dispute with the right kind of information provided. So we're still talking about subject matter expertise, and I do believe that the mediator does have to have some level of subject matter expertise. So to me, what are the areas that the mediator really does need to know about in order to mediate a dispute? I think the mediator needs to have some knowledge of the nomenclature. That is really the language of that particular type of dispute. Otherwise, the whole mediation process will be geared towards educating the mediator on what that nomenclature is. I think a mediator needs to be able to follow the facts of that dispute. So obviously, if you've got a real super complicated set of facts, you need a mediator who is a quick study and can absorb all of those facts. In terms of technical expertise, this is a tough one because the reality is a lot of us are not going to have technical expertise in certain areas like maybe patent, trademark, software. But there again is the beauty of having had experience in those cases where if a mediator has mediated a patent case or a trademark case or a commercial case or a construction case or software case, then they will have some technical knowledge in addition to their legal knowledge and the knowledge of the nomenclature. And then I think with respect to the law, lawyers can educate mediators on the law, but I think the I think the mediator does have to understand enough of the law and enough of the legal issues, the relative strengths and weaknesses of the party's position to know when and how much leverage to exert on the respective parties. The other thing I think the mediator really should know when it comes to subject matter expertise is, are they in a position to assist the parties and the attorneys with an evaluation? Now, to me, that's distinguished from the mediator actually valuing or giving an evaluation. But the mediator needs to try to walk the parties through these little acronyms we have here. The worst alternative to a negotiated agreement, the best alternative to a negotiated agreement, and the most likely alternative to a negotiated agreement. Another thing the mediator should understand is what are the potential outcomes in an adjudicative process, whether it's going to be arbitration, trial by judge, trial by jury, whether it's an appellate mediation and we're going to have a decision from an appeals court. Whatever the method of adjudication is, I think the mediator needs to understand what are the potentials there. And then, very different from that, what are the potential means of resolution? This is where creativity and brainstorming comes in. This is where a mediator can really shine because, as you all know, there are certain things you can achieve in a mediated outcome that you cannot achieve through adjudication. So these are all things that I think that the mediator should know in order to function well in your case. But when it really comes down to it, we don't need to be experts in the specific area of the law that you bring to us to mediate. But what we are experts in process. When I think about realtors talking about the value of properties, what will they always say? Location, location, location. For us as mediators, our expertise truly is in the process. What is the process? Well, the process is mediation. But what are the things within the process that we're experts on? We're experts in communication. We're experts in facilitating a mediation in such a way that it's going to yield a resolution. We're experts in negotiation. And of late, over the last several years, most of us have gotten a lot of additional training in the field of emotional intelligence, which we're going to touch on a little bit today because I think that there is an emotional component in every dispute. And we're also experts in bringing about closure, in chasing that deal and making it come to fruition. Brandon is going to talk to us in just a second or so about some of the different mediation philosophies that are employed by different mediators.
Thank you, Michelle. The most common mediation models that legal practitioners know about are the facilitative and evaluative models, and I want to talk about those today. And briefly I'll touch on the transformative and the narrative mediation models. But first, I just kind of want to step back, have a slightly more abstract discussion about why we have models. Why do we label particular mediation approaches as evaluative or facilitative? Sometimes there's a misconception about the mediation process and the role of mediators in that process. And for decades, philosophical and professional debates have been waged over the merits of competing mediation models. And the model one chooses to apply to one's own mediation practice really reflects some fundamental philosophical choices about the mediation process and the role of the mediator. Start with the definition of the mediation process. Some would say that mediation is an assisted negotiation in which a neutral third party attempts to help parties to a dispute resolve their disagreement. And that's the more common definition, and indeed it's the definition that informs most of the ethical rules governing the practice of mediation in the state of Florida. But there's a slightly different definition that is also quite popular, and that defines mediation as a consensual process that seeks self-determined resolutions. They both have their merits. What I want to do is step back even further and point out that however one defines the process we call mediation, it represents a certain perspective about the goals and means of achieving those goals in mediation. In any undertaking, without a clear understanding of one's goals and an ethical framework that delineates the appropriate means of achieving those goals, the skills we acquire in our profession are just a set of disembodied techniques. A mediator's differing conceptions about the roles that he or she could step into, or the mediation process itself, really drives everything that a mediator does when helping to mediate a case. First, let's talk about defining the goal of mediation. Some folks believe that mediation is a process that seeks to solve a problem. Well, don't want to offer a tautological definition of mediation, so we need to define the word problem. Is it narrowly defined or broadly defined? Some people define the problem that faces mediators in mediation as the problem framed by the parties in their pleadings and reflected in the negotiating positions adopted by the parties prior to and during mediation. The goal of the mediation is to settle a legal dispute by compromise, and the focus tends to be on the past events leading up to the date of mediation. By contrast, people who define the problem broadly seek to solve a problem, resolve a controversy by identifying the interests of the parties that are beneath their negotiating positions. The goal here is to resolve a controversy on terms that are not limited by the pleadings, so as to achieve a long-term and mutually satisfying resolution on the part of all the disputants. The focus of broad problem definition is the future. How are we both going to live in the world tomorrow, next week, and next year? And then we step from goals to actions. We've discussed the goals of the mediation process, but how do we achieve those goals? How much influence should a mediator exert on the parties and this process that we call mediation? Back in the 80s, a foundational article was written by Professor Leonard Riskin at the University of Missouri at the time. He's now at the University of Florida. And Professor Riskin posited the dichotomy between the evaluative type of mediator and the facilitative type of mediator. The Florida model is based on facilitative mediators. And just to borrow from Professor Riskin's foundational approach to mediator styles and mediation models, the evaluative mediator tends to urge the parties or push the parties to accept narrow position-based settlements. The facilitative mediators help parties engage in a conversation wherein they can evaluate one another's proposals, develop and exchange interest-based proposals, and develop options that respond to the interests that are beneath the positions they've adopted in litigation. So there's an important difference in Mediator Philosophies on the goals we're trying to achieve, and an important distinction between the methods that we adopt to pursue those goals. In Florida, because we are a facilitative model state, evaluative techniques are discouraged, and one can debate whether certain evaluative tactics are even allowed. They do happen, and I will tell you that in my experience, in my practice, the marketplace seems to demand more evaluative tactics than the rules would allow. And so at some point, the Florida Supreme Court will probably need to sit down and look at what parties in their counsel are asking of their mediators and determine if some rule modifications need to be made to allow a more evaluative service to be delivered. It is worth mentioning that currently the Florida Supreme Court is considering some rules modifications that could be interpreted as a baby step in that direction. Before moving on, I did want to mention transformative mediation. Transformative mediation has become increasingly popular in recent years as a third model of mediation. It rests on a fundamentally different view of conflict than does problem-solving mediation. Problem-solving mediation, again, seeks to define problems broadly or narrowly, and the transformative theorists argue that conflicts being treated as problems misses the mark. And transformative mediators view conflict as a crisis in human interaction that makes disputants feel vulnerable and self-absorbed, and that their interactions, while they are in dispute, degenerate and assume a mutually destructive, alienating, and dehumanizing character. And this negative cycle prevents people from living in harmony with one another. And I mention it because transformative mediation, while it hasn't caught on as much in Florida as it has in California, it is on the rise, and there are entire mediation firms that practice nothing but transformative mediation. And transformative mediation is basically focused on two major effects, which is empowering the parties to restore them to a sense of their own value and strength, and recognition. Recognition meaning transforming them into a more empathetic state where they can recognize another person's divergent views and interests and accept those as equally legitimate. Narrative mediation is also on the rise, and I'll just briefly mention narrative mediation. Narrative mediation uses the storytelling metaphor, and narrative mediators help the parties at a mediation to interact and develop, contest, and modify their conflict stories, and then help them to write a new narrative, help the parties in dispute create a new story wherein they can create a cooperative climate and destabilizing theories of responsibility, where the parties' pre-conflict stories tend to blame one another for their problems and park the storytellers in alternating states of victimology or demonizing the other side. Narrative seeks to tell a new story in a more harmonious light, and the idea is to leave the parties in conflict with a new view of each other's interests and positions, and in this new climate of openness come up with a narrative that makes sense for everybody over the long term. So these are four different mediation models that reflect very different mediation philosophies, and the fundamental choices people make about the goals of mediation and the tools that we use to achieve those goals. And it's important because before you hire a mediator, I think you need to know whether their style tends to be purely facilitative, or do they deploy evaluative tactics where necessary to help the parties get to where they want to be? Are they a narrative mediator? Are they a transformative mediator? These are important things you don't want to learn on the day of mediation. You want to ask about your mediator beforehand and determine if you've got the right person for the job. Next slide, please.
Thanks, Brandon. I think probably in Florida we find more mediators who either fall into the facilitative or evaluative. Wouldn't you say that's the case?
Yep, absolutely. And there are evaluative mediators we all know and love who have a very defined style that can be offensive to some people under some circumstances. So it's critically important to know if your client doesn't like being spoken to in loud tones of voice and bullied about the facts of the case, perhaps an evaluative type tactic is not the one that's appropriate for your particular client's mediation.
Yeah, and I've actually had some conversations with some lawyers who have litigated with an evaluative mediator, and their client wasn't one bit happy about how the mediation went down. I think that there was a lot of external pressure in the 80s when mediation first got started for there to be evaluative mediation, for there to be what we might call arm twisting. But as we have progressed over the last 25, 30 years, I think that particularly I can think of an example where I have mediated with some CEOs of publicly traded companies, and top dogs like that are not the least bit impressed with a mediator who thinks they're going to bully them into a specific type of conclusion or outcome. So I think, you just have to find the right mediator to fit the fuss. It's probably the best.
That's true, and evaluative mediation approaches can be extremely problematic, say in a family litigation where the people are on emotional high alert, or in a David and Goliath business dispute where the case and the outcome of the mediation really will determine whether some small business person sees the end of his or her body of life's work at the whim of a Fortune 100 company. I mean, people get very emotional in these situations. I've had business cases where the small business person is every bit as emotional as the spouse whose 30-year marriage is unraveling, and you got to be very careful about evaluative tactics in these types of hot and emotionally violent mediations, because people don't like being pushed around.
So now we'll talk a little bit about some of the ethical considerations that a mediator has. If you haven't been through the mediation training in Florida, you're probably not familiar with some of the ethical considerations or constraints that we as mediators operate under. So we're going to spend a little bit of time here today covering those so you have a better understanding of, what rules actually govern us. So there's really three sources that we look to, and they're highlighted here for you. And whenever there happens to be a conflict between the rules of professional conduct and the rules for certified and court-appointed mediators, the rules for certified and court-appointed mediators trump the rules of professional conduct if you are an attorney serving in the capacity as a mediator. So that's just something to keep in mind. So the first consideration we look at is the mediator's role, and we've pretty much got it laid out here for you what the role of the mediator is. I would want to mention just for a minute that the last point is decision-making rests with the parties. One of the things that really distinguishes mediation, and one of the things that one of the theories that plays out through all of the ethical constraints on mediators is the self-determination of the parties. So that's a biggie. It is absolutely necessary that the self-determination of the parties in the context of the mediation prevails. Now we're going to talk a little bit about impartiality, and when I was preparing for this, I was examining the rule and I was giving it a little thought, and you notice in the rule that it doesn't say anything about the mediator not having an opinion. Mediators have opinions. That's something that everyone should recognize. Because we have opinions because we're human. But what is our ethical obligation? It is to have freedom from favoritism or bias in connection with what? Our words, our actions, and our appearances. And I want to make mention here that if we can't be impartial in that respect, then we need to withdraw. I mean, that is our ethical obligation. Another thing that this particular rule discusses is that a mediator can neither give nor receive a gift in connection with the mediation process. Now, we actually have some MEAC opinions on this. I don't think we're going to discuss those today, those particular opinions. Brandon's got some opinions he's going to discuss with us, but the ones related to, believe it or not, there are some MEAC opinions related to buying people lunch and serving lunch, and so here's the long and short of that. A mediator may provide cookies, refreshments, food, all of those things in connection with the mediation process, and those are considered to be de minimis. But that area, the greater the value of the item provided, the more it moves into the gray area. So just wanted to make you aware of that little prohibition there. And also, you are not, as a mediator, not to solicit future professional services. Now you might say, well, how could this even come up? Well, it could come up in connection with, let's say you're a lawyer, but you're functioning as a mediator. What this means is they do not want you to try to form some type of attorney-client relationship for the future, to offer your future services as a lawyer as a result of someone that you have encountered or met in the mediation process. And this is one of the reasons we think that it is helpful to have a full-time mediator, because they would have no incentive or no desire to acquire a client for purposes of legal representation.
And unfortunately,
so now,
I'll just add, Michelle, there are mediators who have the reputation of trying to establish future attorney representation clientele wearing their mediator hats, and it's not appropriate.
No, not at all, and these rules are very clear about that. And then we get into what really served as the genesis for us to explore this presentation, and that is conflicts of interest. So basically, we've got two types of conflicts of interest that these rules address. They have, the Rules Committee has basically established these two types. Some are waivable and some are non-waivable. And the ones that are non-waivable are what they categorize as clear conflicts of interest. The problem with the rule is it doesn't specifically define what a clear conflict of interest is. There's some mention of what that might be in the comments, and as you'll hear from Brandon when he moves forward with these MEAC opinions, there's certainly some discussion in the MEAC opinions and some guidelines about what would be a clear conflict of interest and thus non-waivable, and what would be a waivable conflict of interest, which would be, which obviously would not be a clear conflict of interest. And then we also have two origins for the conflict of interest, what they originate from. So they could either be relationship-oriented or subject matter-oriented. And Brandon's going to talk to us a little bit more about some specific examples of those and how they play out in terms of whether they constitute a waivable or non-waivable conflict of interest. Now, the obligation to disclose a potential conflict of interest or a conflict of interest rests with the mediator, period. I mean, it is the mediator's obligation. It is not the lawyer who's retaining the mediator. It is not their obligation. And this obligation arises and is to be communicated as soon as practical after the mediator would become aware of either the interest, which I define now as the subject matter, or the relationship. So, when I sit back and I think about this, timely disclosure is not at the mediation table. That is not considered timely disclosure because at that point, the parties are ready to go, they're geared up, the attorneys are ready to go, they're geared up, and it's really not appropriate to make disclosure like that at the last minute. Having said that, there are situations where a mediator could have exercised absolute due diligence to determine whether there was a conflict of interest, and perhaps there was no way to determine prior to the mediation that there really was a conflict of interest. So wouldn't necessarily throw the mediator under the bus for not disclosing it sooner, but certainly should be disclosed much earlier in the engagement process. Now, what are the effects of disclosure? In other words, once disclosure is made, where do we go from there? Well, the mediator's obliged under these rules to withdraw if there's a clear conflict. However, the mediator can serve after the disclosure if all the parties agree and there is no clear conflict. So Brandon is hopefully going to shed some light on what is and is not a clear conflict in his discussions on the MEAC opinions. Here's a couple of more things regarding conflict of interest. And this makes sense if you think about it. The mediator can't create a conflict of interest during mediation. Well, you'd say, well, how would that occur? Well, I can think of a couple specific examples. Let's say I'm mediating a large commercial case, commercial foreclosure case. And so as a result of that mediation, I become aware that there's a piece of commercial property that the parties want to sell, and they could probably sell it at a distressed value, and I could probably get a real deal on that. Let's complicate it even further and say that as a result of mediating a case, I'm a realtor. Let's say I do actually have a real estate license. It's inactive, but I have a real estate license, and I have had it active throughout many years that I functioned as a mediator. Kind of same thing where I'm prohibited from saying, oh, gee, I know a real estate agent that I've worked with in the past, and I can refer you over to them, and then, of course, me take a referral fee on that. I mean, you can see how that would be absolutely prohibited. So there are interesting opportunities that arise in the context of a mediation where if a mediator was not being ethical, they could certainly create a conflict of interest in the context of the mediation itself. And then we kind of already alluded to mediators should not provide any services other than mediation. We've kind of already alluded to that previously in connection with one of our other slides. Now here's an area I'm not going to spend a lot of time on. My recommendation is if you really want to delve into this, take a look at the rule itself. It was recently amended in 2014. But if you look at it, it's pretty restrictive. It applies to senior and retired judges, and quite frankly, I'm not sure, the rule didn't clearly define that, and I'm not sure what the difference is between senior and retired judges. But basically, it almost it pretty much prohibits you from, if you're a presiding judge in a certain circuit, even if you're retired and you're on some cases in that circuit, you pretty much can't mediate in that circuit. And then the same would go if you're mediating in that circuit, you pretty much can't take any cases as a senior or retired judge. And we see those prohibitions kind of spelled out a little bit more specifically in this particular slide. So that's something to be cognizant of. If you're going to hire a retired judge or a senior judge, they should be aware of these rules. But sometimes people, are not as careful about trying to comply with rules as they should be. Now I'm going to take a few minutes and discuss a case here. It's called Vitakis Valsheen versus Valsheen. And as far as I know, this is the first time that a court ever held that a mediator's violation of ethical standards could be the basis to set aside the parties' settlement agreement. And when you think about that, that is a pretty significant ruling, because that means that the parties could be perfectly willing. I mean, you would assume there would have to be some prejudice on the part of one party or the other, but basically it kind of opens the door to the possibility of parties reaching a valid settlement agreement and then having buyer's remorse and then trying to pin some ethical violation on a mediator for purposes of setting aside the agreement. So the case is pretty significant, so I'm going to spend just a couple of minutes here kind of going through the facts. There was a husband and wife, and they went to divorce mediation, and the mediation lasted 7 to 8 hours. And the mediator made, according to the wife, who filed a motion, basically what happened is the parties entered into a settlement agreement. The court entered a final judgment based on the marital settlement agreement, and about 30 days after the entry of the final judgment, the wife, now pro se, she was previously represented by counsel, both parties were represented by counsel during the mediation. The wife, pro se, moved to set aside the marital settlement agreement on the basis that she was coerced by statements made by the mediator in order to induce her to enter into the settlement agreement. And at the mediation, there were a couple significant issues, one of which was there were some frozen embryos that the parties owned. I guess that's the best way to put it. And in her hearing, in her motion to set aside the settlement agreement, the wife testified that the mediator had told her that the embryos were not lives in being, and that the court would not require the husband to pay child support if she were impregnated with those embryos after the divorce. Further, the mediator told her, and this is, of course, all her allegations, that the judge would never give her custody of the embryos, but instead would order that they be destroyed. She even said that the mediator at one point came into her private session room, threw his papers on the table, and declared, "That's it, I give up." And then, according to the wife, the mediator said that if there was no agreement reached, that he, the mediator, was going to report to the trial court that the settlement failed because of her. Then there was another issue relative to the parties' pension. The mediator, even though there was no evidence at the mediation on the value of the pension, the mediator told the wife, and again this is according to her testimony, that the husband's pension was worth about $200 a month, and that she would spend $70,000 in legal fees to try to obtain this $200 a month worth of the husband's pension, and that therefore her costs in trying to achieve this modest return wouldn't be worth it. Well, it turns out that there was evidence later on that her legal fees for that would have only been about $15,000. So there was certainly a lot of, where there's smoke, there's fire. There was certainly a lot of smoke here. And initially, the trial court denied her motion because the trial judge said, we don't have any authority in front of us to convince us that a mediator's violation of their standards would be the basis, a proper basis, to set aside your agreement. So then what happened is it went to the appellate court. The appellate court said, oh, no. We hold that the trial court, may invoke its inherent power to maintain the integrity of the judicial system and its processes by invalidating a court-ordered mediation settlement agreement obtained through violation and abuse of the judicially prescribed mediation procedures. So now we have on record a case, ultimately, just so you know, ultimately the appellate court remanded it to the trial court to consider what actually happened in mediation, to consider, all of these statements and whether or not it would serve as a proper basis to prove coercion. The trial court on remand found no mediator misconduct. So obviously the judge did not believe the statements made by the wife. But this case, sets a pretty interesting precedent, because now we see that not only is it important for a mediator to abide by ethical standards to ensure that the mediation process is properly conducted, but we see that it can have some very significant consequences on the parties. So Brandon's going to talk to us a little bit now about some MEAC opinions, and so you'll get a sense of how these rules that I've covered will play out in real life.
Thanks, Michelle. In 2000, the Supreme Court of Florida enacted the rules that Michelle was speaking about. Since that time, the Mediator Ethics Advisory Committee, which we refer to as MEAC, has applied the ethical policies in the rules to particular factual scenarios that arise and may be submitted to MEAC by mediators. And then MEAC issues opinions. And I want to talk today about 5 particular opinions that bear on the issue of why it makes sense to hire a full-time professional neutral rather than a mediator who has one toe in the pool of litigation and another toe in the world of mediation. The first opinion is a 2009 opinion. It's 2009-009, and that MEAC opinion says that where there is an attorney-client relationship between the mediation firm and your law firm, then you may not serve as a mediator or an attorney in that case. That is the clear import of the opinion. So, for example, law firm A has an attorney who writes the employment benefit plans for law firm B. Then a mediator from law firm B may not serve as mediator on a case where law firm A has an attorney of record as part of the mediation process. 2002-005 is the second MEAC opinion I want to talk about. And in that case, the fact scenario submitted to MEAC was a conflict in the context of a mediator who is also an attorney practicing at a law firm. 2002-005 states that these circumstances create a clear conflict of interest that is not waivable when a mediator who is asked to serve in a case involves a party in the mediation against whom the mediator's law firm had pending cases. So if you're asked to mediate a case and your firm has lawyers who are currently litigating against one of the mediation parties, you may not serve as the mediator there. It's a clear conflict of interest, and it cannot be waived by the parties. And the opinion goes on to state that there is no difference, factually or ethically, between the law firm representing one of the parties in the matter or representing a party involved in litigation other than that litigation against one of the parties to mediation. Let me repeat. The opinion goes on to state that there is no factual difference or ethical difference between the law firm representing one of the parties to the mediation or in representing a party in other litigation against one of the parties to the mediation. 2008-007 is a MEAC opinion that states a clear conflict of interest exists when a law firm in which a mediator is a partner is part of an adversary proceeding involving a party to the mediation. I'll repeat. 2008-007 says that it's a clear conflict of interest which cannot be waived when a law firm in which a mediator is a partner is a participant in an adversary proceeding involving a party to the mediation. Finally, the 2003 and 2010 opinions say basically the same thing. They state that there is a clear conflict of interest if a mediator once acted as an advocate either for or against one of the parties to the mediation. So you can see that there are some very tight restrictions upon the abilities of a mediator to wear two hats. Even if we're talking about prior representation in matters that are now resolved. These MEAC opinions are intertwined. The effects of the opinions as far as their restrictions upon what mediators can and cannot do are inextricably linked. And the truth is, based on the relationship conflicts that the MEAC opinions delineate, I find it very difficult to imagine how anybody could serve as a mediator on very many cases in the same subject area where he or she practices and has been practicing for a while. It's just going to be very, very difficult because you're going to invariably one day run into one of these conflicts, and you may not know it till it's too late. So the safer bet is to either choose. You're going to be a mediator or you're going to be a litigator. Next slide, please. Briefly, I thought I should touch upon a few of the Florida rules of professional conduct that bear on this whole discussion. If you're a lawyer, you hire a mediator to mediate your client's controversy. Well, what do you need to be careful of as a lawyer when selecting your mediator? Because if you select a mediator who has one of these kinds of conflicts, you may not find out about it until it's too late, until your client grieves you for hiring a mediator who has some ethical prohibition on his or her ability to serve as the mediator in your client's case. If you take a look at 4-1.2a, and all these rules, by the way, these are from the Florida Rules of Professional Conduct, of course, and they fall under the chapter heading Client-Lawyer Relationship. And 4-1.2a says that a lawyer shall reasonably consult with the client as to the means by which the client's objectives of representation are pursued, and the lawyer may take such action on behalf of his or her client as is impliedly authorized to carry out the representation. Well, why do we focus on that? Well, how can you reasonably consult with your client about the means of pursuing the client's objectives if you are recommending hiring a mediator who has one of these conflicts lurking, one of these relationship-based conflicts? Rule 4-1.4 concerns itself with communication. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. I contend, my professional opinion is that you need to do due diligence every time you hire a mediator to be absolutely certain that your mediator does not have one of these kinds of conflicts that we've referenced. If not, my opinion, you've committed legal malpractice. 4-1.1 concerns itself with competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. My belief, again, this is my opinion, but if you hire a mediator who has one of these conflicts, you have acted incompetently and exposed yourself to a grievance. And the easiest way to avoid these types of potentially catastrophic problems is to hire a full-time professional neutral rather than some lawyer against whom you litigated years ago and happen to like socially and is now your friend. That's not a good reason, no matter how well you get along with the person, unless you thoroughly vet this person's credentials to ensure that there are no conflicts. Next slide, please. What I want to talk about now is an area of the mediator rules that is far less defined. It's very gauzy whether issues-based conflicts are waivable or non-waivable. I want you to imagine a situation where a lawyer has a client whose volume of litigation is greater than 1/2 of that attorney's practice. And that client has instructed the lawyer, because certain issues come up repeatedly, that under no circumstances must issues A, B, and C ever see the light of day in an appellate court. Now I want you to imagine that this lawyer also serves part-time as a mediator. Lo and behold, the lawyer shows up one day for a mediation, and granted the parties are different than the client this lawyer represents, but the mediator is mediating a case which concerns issues B, C, and D. Well, B and C, this lawyer's biggest client, has instructed must never see the light of day in an appellate court. How can you, in good conscience, and this is a rhetorical question, how can you in good conscience say that you are neutral as to the outcome when your biggest source of revenues, your largest client, has instructed you that issues A, B, and C must never see the light of day? Are you going to push a little bit more for one side? What if one side decides in 30 days, like in the Vitakis-Falsheen case, that they don't like the settlement, and they learn that you represent a large institutional client who instructed that the very issues were settled under your oversight at mediation are the issues that your client was never allowing you to take up on appeal? This is an issues-based conflict, and it is my contention that issues-based conflicts are never waivable. These are clear conflicts. And so therefore, if you have a part-time mediator with a toe in the pool of litigation, almost never would that individual be able to serve as a mediator without a clear conflict of interest arising based on the issues that this individual litigates wearing a different hat. So that is an issue that needs to be cleared up by the Florida Supreme Court, because right now we're all sort of flapping in the wind without a definition of what constitutes a clear conflict. But you can imagine numerous factual scenarios in addition to the one that I laid out that would require a mediator to decline an opportunity to mediate on a case. What I'd like to do now is something we've never done before. We have a couple of questions that we have devised. This program allows us to take a poll, and we've got 2 questions we'd like you all to answer. And if it works correctly, you'll have about 20 or 30 seconds to click your answer, and then we'll be able to display the results of the poll immediately on the screen to you. So I think I'll go ahead and get the person with the controlling mouse to click up the first question. Have you taken part in a mediation where one or more participants were too agitated to make rational business decisions? And you can see you have 3 answers. Yes, more than once. Next one, only once. And the last answer, not yet. And if you'll please go ahead and vote. I will not vote, neither will the organizer. We'll go ahead and display.
Nor will I.
We'll display for you in real time what the results were. There we go. So you can see half of the people have not had this come up, but almost half have had this come up more than once, where one of the participants is too agitated to make rational business decisions. And I'll tell you why this is important in just a second. Next question. Have you participated in a mediation conference where one or more of the attorneys was too emotional to perform his or her job? Go ahead and vote. Same options for answers. Go ahead and display those results, please. Not happened in 73%, but in more than one case, 20% of the people have had this happen, where one or more of the attorneys was too emotional to perform his or her job, and over a quarter of the respondents say that it's happened at least once. Now, why might an attorney be emotional at a mediation conference? Well, I submit to you that if and please go back to my next slide just after this one. If the attorney is emotionally engaged because that attorney wears 2 hats and serves as a litigator and a mediator, and the same issues come up in both contexts, that would make you pretty emotional. So, Michelle, I think you're taking it from here.
All right. Well, that worked, didn't it?
It did.
Okay, so now we're going to just spend a little bit of time, because we really only have about 10 minutes or so left. You know, Brandon has kind of given us the perfect segue here with the polling questions that he put out to the audience. And so there's a couple things I want to say about your brain and how it functions. You don't really have 3 anatomical sections in your brain, but what you have is 3 different functioning sections in your brain, and we refer to them as cognitive, emotional, and social. And cognitive, there's a lot of data out there on cognitive biases. We're not going to spend a lot of time on that today. I'm just going to try to define it for you and tell you that social scientists have already identified over 30 different types. Here's what a cognitive bias is. You have to assume if humans were completely rational in their decision making, what would they do? They would gather information They'd examine a wide variety of alternatives, and then they'd make decisions that would maximize their own personal interests. That would be a very rational, logical, decision-based analysis. But we know this isn't what happens. And part of the reason is that we're human. And so we all are cognitively limited. We're not like robots and machines. We do have limits in our cognition. So what I'm going to identify here on this slide, and I would be more than happy if you email me. I can have a conversation with you about what these are, how they impact you in the mediation context. I've also written an article that I could email to you if you would like, so probably the best thing to do is just email me about this. But I bet you that you have seen sunk cost effect, which is a cognitive bias, and anchoring, which is a cognitive bias, in your mediations. Anchoring is a phenomena that kicks in, and what it does is negotiations will revolve around an initial reference point, such as a demand. And they've done all kinds of extensive studies on this, and the bottom line is, even if the anchor is arbitrary, it still influences the negotiation range. So anchoring is extremely powerful cognitive bias. And then sunk cost effect, that of course is the situation where you've invested lots of money in litigation, and now that's impacting your decision making in whether to litigate the case going forward or to settle the case. And we can talk a little bit about that one-on-one, or I can provide you with some written information. But the one thing you do need to be aware of that we can mention fairly quickly here is that in mediation, there is a significant effect of stress and fatigue on cognition. This basically measures the level of stress, and you can see on the left side, if you have zero stress, the person's fatigued, bored, and you may have experienced that in some of your mediations. Somebody comes to mediation and you can tell they have no interest in settling and they're barely participating. By the same token, you don't want somebody way over on the right-hand side who is so stressed out they really can't effectively participate because their cognition is impaired by the stress chemicals that are being circulated in their body. So here's just a little diagram of the amygdala, which is the part of the emotional brain that is the hot reactor or the quick reactor. We call it, Daniel Coleman, who's a social scientist, he calls it the low road because it functions independent in a lot of times from the cognitive part of your brain, so that if you see an upsetting phenomena, you're going to register it at your amygdala or your low road level, and then you will register it at your cognitive level. Then your cognition will have to interpret the information, but the reality is the chemicals and the feelings are already present before you have the opportunity to look at the situation from a cognitive standpoint. Fear and reward are very important in the mediation context. You want some fear because fear is a highly, highly motivating factor, but you don't want so much fear that the person can't make good decisions. And you're going to see on this slide what happens and the differences between what happens when you have fear and when you have reward. Now, if you compare those, you will see that cognition is way up on the reward side and it's down on the fear side. So if there's too much fear in the mediation context and not enough focus on reward, then the person isn't going to be able to make good decisions. One of the other things I usually like to talk about in the context of the emotional brain is empathy. And we have listed here the elements that are necessary for empathy. But what I want to suggest to you is when you empathize with someone, remember that you are taking on their affective state. And when we say that, what we mean is their emotional state. So you don't, in a catastrophic death case, or in a situation where there's a catastrophic illness and you're in litigation on some matter related to that, whether it's a strict liability case or whether it's an accident case, you want to convey to people who are significantly injured that you appreciate and understand, and you actually affirm the validity of their feelings. But if you actually start to feel the way that they feel, you're going to be significantly hampered in doing your job. So it's funny, for years we've talked about the advantage of being empathetic. Empathy is extremely important in the context of personal relationships, but in the context of our professional work, we need to engender empathy, get others to empathize for our client, but we, to be effective in negotiating, need to take perspective, engage in perspective taking. Couple other things that I will touch on, because I know we're getting short on our time. Eye contact is very important in mediation, and it communicates a lot of things from a social perspective. Too much eye contact can be threatening, it can be a challenge for dominance, so it is threatening. But lack of eye contact is threatening because people are wondering, why won't this person look at me? So I have a couple recommendations in mediation. Do look at folks, do shake their hands, do try to connect with them through eye contact. And I know this is a tough one, but if the situation is appropriate, it's great if you can smile at someone. That eases a lot of tension in the room. Brandon, I think I'm going to hand it over to you now to finish up. And
yeah, go to my next slide if you would, please.
Go where now?
To my slide.
Yeah, okay.
The first one with the graph. Here we go, this next one. Why is it important for mediators to understand the nuances of the human emotional brain? Click the next one, please. Because every day we encounter situations that make us more or less capable of dealing with the realities of life. You can imagine a highly emotional situation where you're walking down the street, click the next one, and someone slaps you in the face. You can also imagine a situation where you're sitting in a statistics class and learning about bell curves. Next slide. When someone slaps you in the face, your logical brain is all but turned off, and your emotional brain is on high alert. Click the next one. Whereas by comparison, when you're in the statistics class, your logical brain is the predominant part of your cognition that is causing you to form certain thoughts and behave in a certain way. Next one. The truth is, throughout the day, we encounter situations that have us all over the place, some more emotional, some more logical. But if you look at the next slide, you'll see that the average of where a normal person, that is a person without cognitive deficits or emotional conditions, the average is somewhere in the middle of all of these different situations in which we find ourselves. And we as mediators, by understanding this, next slide please, have the ability to take people from the more emotional state, the next slide, where people make bad decisions. They don't make rational business decisions. They don't make decisions in their long-term best interest or in the best interest of their family, their coworkers, their employers. Next slide. What they do is they make irrational decisions. And so we as mediators spend much of the day when we understand the emotional barriers that a particular party faces, trying to get people from the red zone down into the green zone. And somebody who is enmeshed in the combat of litigation, who doesn't study these processes like full-time mediators do, may not be as capable of defusing a highly emotional situation where your client is not able to do what is in his or her best interest and make a decision in the green zone. So that's really the last piece of this, and that's one reason I believe very strongly that your best bet is to hire a full-time professional mediator. Thank you so much for your time today. I'm going to turn it back over to Michelle.
Thank you for joining us, and please keep your eye open for our next webinar. It's going to be presented by partner Kimberly Sands and shareholder Richard Lord, and that topic is finding leverage and maintaining tactical advantage in mediation. So please join us at noon on Wednesday, April 29th. I also want to point to our Florida Bar course number, and I will read it for those of you who are not in front of a screen. That is course number 150168-6N, 150168-6N as in Nancy. And this webinar qualifies for 1.5 CLE credits. So it's 1.5 general and 0.5 ethics. And I just again want to thank University of Florida 11 College of Law Institute for Dispute Resolution. Thank each of our participants today, and thank you, Brandon, for bringing this topic to my attention so that we could put together this webinar.
I enjoyed it. Thank you, Michelle.
All right. Y'all have a good afternoon.